Okay, welcome to another episode of Just Legal History. I'm your host, Mike, and today I am joined by defense attorney Anne Benaroya. Uh, um, you've done many cases over your career, but you're unfortunately or fortunately been there's one that's become public, and so today we wanted to meet and discuss and talk about some of the miscommunications that have been said about the case over the years. And the case that we wanted to talk about today was the murder of Heyman Lee, and you were involved because you were the attorney for one of the people involved, Jay Wilds. And so one of the topics that you wanted to talk about was the plea deal and whether or not Jay did the plea deal for immunity. Is that correct?
No.
Okay.
I wanted to start out with describing immunity, but again, because Jay Wilds, I didn't meet Jay Wilds until he had had 3 formal interrogations with the police and had incriminated himself without any deal in place. So by the time I met him, it was impossible for Mr. Wilds to make a plea deal for testimony against anybody. He could have been compelled to testify any time after his initial self-incrimination on February 28, 1999. He confessed to the police his own involvement and his co-defendant's involvement 28 February 99. There were a lot of issues that I have raised at the time with Miranda and other such things. But his initial interrogation was 28 February 1999. There were 2 custodial venues. The police station, Fayette Street, the police seized Mr. Wilds' person from the video store where he worked. They transported him in the police vehicle to the Fayette Street police homicide headquarters. We don't know what, if anything, was discussed in transit. But we do know that Mr. Wilds was in custody. He was not free to leave. The definition of being in custody is not free to leave. When they arrived at the Fayette Street police station, again, it's unclear. It looks like about midnight, maybe. The police gave Mr. Wilds Miranda warnings. He waived. Again, we're talking about police procedures from 25 years ago, and the law has changed quite a bit since then, and the police procedures have changed quite a bit since then. So the police would have brought Wilds into the police station, asked him questions about his involvement before they made any kind of a record. Because remember, what we have, the kinds of records that we have now, we didn't have them back in those days. We were stuck with whatever the police put in writing or decided to put on audio tape. We didn't even have videotape. So the records of this guy's particular interrogations are precious little. Anyway, so he gets they interrogate him in a police station for, I want to say, an hour and a half or something. And then they make an audio tape at the end of which the audio tape record is like a police report. The police decide what they want to go into the record. They're summarizing what has transpired previously. They finish up with the Fayette Street interrogation. We'll call that the first custodial venue. When interrogation is custody and interrogation, the venue was the police station. And then they decide they're going to take Wilds to show them. He says he'll show them where Hayes' car is located. So when they put him in the police vehicle, that's the second custodial venue, and he shows them where Hayes' car is. What's significant is that between the 2 custodial venues and the amount of self-interrogation, the evidence that Wilds gave the police, coupled with the evidence they already had, was enough for the police to charge Mr. Syed with murder on March 1st, meaning within a few hours after releasing Wilds. Why is that significant? Because the police could have charged Wilds with the same murder, granted as an accessory after the fact, but nevertheless the murder. So what's significant is Wilds gave the police his entire confession without any deal in place. That means that Wilds' testimony against Syed or anybody else the state could have compelled Wilds to testify against anybody thereafter. And by compel, let's be clear, that means the state could have subpoenaed Mr. Wilds to testify. there was no deal in place. So Wilds had it wasn't like he said, okay, well, I'll testify in exchange for reduced charges. That didn't happen. That's usually the way it goes, but it didn't happen here. And why it's so important is the type of immunity a person in Wilds' position gets from a plea deal is called pocket immunity. It's an informal immunity, and it is not coextensive with the Fifth Amendment. For purposes of derivative use immunity, meaning using Wilds' testimony to prove perjury, informal contractual immunity per a plea deal is much weaker. The type of immunity Wilds had was very strong. It was Fifth Amendment constitutional formal immunity because he got nothing in exchange. He didn't have an attorney for 6 months. He had all those interrogations and police encounters. So the point being, every police encounter he walked into after 28 February, he's scared that he's going to lose his liberty because he knew the police had probable cause to charge him because they charged his co-defendant. So his liberty was at stake. So to all the people that have been saying, oh, the police threatened Wilds with a death penalty or whatever, that's utter nonsense. The police didn't need to make an affirmative threat. It was what they didn't do that was the greater threat.
Okay, sorry to interrupt, but I just want to make sure, because that's been kind of contributed, but the cops never officially gave him a death penalty threat. They never...
He wasn't, neither of them were eligible.
Okay.
Had the police made such a threat, it would have dismissed the charge against Wilds. I mean, we wouldn't, if that was, again, that's inherently coercive. I mean, the police lied to Wilds. There's no question about that. They led Wilds to believe he was merely a witness, and we'll get to that later because, again, the fact that they didn't charge him, again, that's the sort of Damocles hanging over this guy's head. They could charge him any time. The minute they charge him, he's entitled to public defender representation. The problem that has existed ever since when, and still exists, is that a guy in Wilds' position is not, the public defender agency is not allowed to represent. I know because I worked there for almost a decade. We're not allowed to represent people until they have been charged with a crime that carries incarceration or that compromises their liberty. Whereas Wilds was not charged, so he was in greater jeopardy. He went to the public defender office and applied in June, and they couldn't represent him because he was not charged. And so the police, by not charging him, violated his constitutional right to counsel. I mean, again, that's about the torts, and that goes to the sentencing. But my whole point is that here's a guy, this Wilds guy, who at any time after 28 February could have been charged with murder and could have been compelled to testify against anybody else with an immunity order. The state, there's a process the state has to follow. The state will petition the court for an immunity order,
So let's get back to the timeline a little bit first. So we talked about how on the 28th, Jay goes into Fayetteville Street.
Right.
Fayette Street. And he confesses there. He gives the kind of the audio recording that we get there. They then break it up and they put him in the car and they take him to where Hayes' car is behind the row house.
Right, because he told them that he knew where it was. But that's a second, again, depending on how one looks at it, I think that, again, there should have been a second Miranda warning, but there wasn't. What they tried to do was renew the first Miranda warning on the audio tape, but they had to give Jay new Miranda warnings because they changed custodial venues. Okay,
but then he shows them the car, and then then kind of the cops kind of let Jay go because they're not quite sure at that time what they're going to do. So they do two things at the time. They get the crime scene unit out to process the car, and then they go to the court and they ask for an arrest warrant of Adnan in the morning. Those are the two things.
They did what they did. Presumably, again, they had to secure the crime scene. The car was a crime scene, so they secured the crime scene, presumably. Released Wilds to his own devices, and they put what's called a statement of charges in Maryland. Again, if this happened in the feds, the police could not have used a statement of charges. They would have had to have convened a grand jury. But in Maryland, they are allowed to use what's called a statement of charges to charge Mr. Syed And then the way they serve a statement of charges for murder or any serious felony is by way of an arrest warrant. So they were able to arrest Mr. Syed the next morning. But my point is that the police had, because we know that they did those things with Mr. Syed, they could have done them with Mr. Wilds. That's my point.
Okay. So then,
Us.
so not that there's a lot of things that happen in the 2 weeks, but then 2 weeks later, Jay Wilds, the cops come to like his apartment or his house, and they find him and they bring him in for a second interrogation, like on March 15th.
Correct. They seized the person a second time, a second custodial interrogation. They had to give him new Miranda warnings. He allegedly waived, but here's the issue with that. Wilds was situated completely differently with the second interrogation. Anything that happened with Wilds after the first interrogation, because Wilds was in jeopardy. Wilds walks into any subsequent police encounter, whether it's a lineup, a show-up, an interrogation, anything subsequent to 28 February 1999, with the knowledge that the police can charge Wilds with murder, albeit as an accomplice, maybe as an accomplice, maybe as accessory after the fact, but he knows they can do that because they charged his co-defendant and arrested him. So Wilds knows that. So my position has been that was inherently coercive.
Okay.
Because the police had a duty to reach out. They should have contacted. There was a procedure at the time. They had a duty to contact a prosecutor, who would then contact the panel that I was on after I was a public defender, where for free attorneys for indigent criminal defendants like Wilds. They had an absolute duty to do that. Because Wilds, he was in jeopardy. When he walked into the the February interrogation, he was not in jeopardy. In other words, the police couldn't charge him with anything. However, any time after 28 February, they could, because there was he himself had given them probable cause. And that is really important because it goes to all of what Wilds' rights were vis-a-vis his plea. Like, could he plead guilty for testimony? Absolutely not, because he'd already given it to the police. He had no consideration. He could plead guilty we could make a deal for reduced charges.
Let's do the timeline and get through that first, and then we'll talk about that in just a minute. So then he does another taped interview on the 15th of March. Another one that's more questionable too is like he had a ride along that we don't have as much notes for. In
April, yes. That was absolutely, that violated a number of constitutional rights upside down and sideways. Yeah, that was where the tort, the torts had already started happening, but yeah.
Okay, and then Adnan goes before the grand jury convenes, and they bring a charge against Adnan.
Right, they indicted him. They voted a true bill on all the charges, I think.
And then a trial date would have been. I mean, there's a lot of things that happen in the background. So he would have been scheduled for a trial sometime, like at the end of the year or whenever the trial date. But remember,
again, we have one guy has already got a trial date set. The other guy hasn't even been charged yet, which is a problem for the guy who hasn't been charged.
So now we're getting to that. So in September 7th, Wilds was brought before your attention.
Well, I was going to court. Evidently, I was going to court anyhow for this. a parole agent who had shot at my client's house. Long story. And I think Mr. Urick. I had an attempted murder trial with Mr. Urick in late August. I'd been in a car accident in a tractor trailer ran into me in April, so I had to postpone all my cases, all my trials until August. And in August, Urick and I did an attempted murder trial and with McCurdy that acquitted in 4 hours. It came back real quick. It was right before, I don't remember whether it was a Thursday or Wednesday, whatever. But Urick asked me to talk to a quote-unquote material witness. So I'm thinking, okay, well, typically material witness means there's going to be a material witness is not someone who is in jeopardy. It's someone who is merely a witness who is likely to disappear. And so the state can put a warrant on them to keep them to hold that person until trial. Now, because that person's a material witness, even though witness doesn't have any of the same rights a defendant has, a material witness who might get served with a material witness warrant does have the right to an attorney because the material witness warrant is an arrest type of an arrest warrant. It restricts that person's liberty. But, again, all Mr. Urick told me was material witness. He did not tell me this kid had been in jeopardy for 6 months previously and was just none of that.
Okay, so you meet Jay in Kevin's office, and then you go to a different office.
No, I didn't meet him. I met him at the courtroom. It was weird. Here's this kid, with a police escort, and I'm wondering what the hell. Have they already served him with a warrant? I don't even remember. I don't recollect Mr. Urick or anybody from the state's attorney's office as even being there. And again, the state's attorney's office is in the courthouse. So it's like we have the courthouse, we have the courtroom, we have the judge's chambers right behind the courtroom. So all this stuff is right near each other. But if I remember correctly, I had to call the state's attorney's office. Again, this is back when we had some flip phones. Here I'm calling the state's attorney's office. Is this the right guy? I mean, and the cops were, so now I don't remember exactly how I figured out who was who, but I finally did. And Wilds and I go into a little room. It was like, again, it was a jury deliberation room, and Wilds tells me, what are the cops doing here with you? What's going on? You got a homicide here with you. What the hell is going on? And Wells would have told me the stories, and that would take like 5 minutes to figure out, wait a minute, dude, you are in jeopardy. You could be charged with murder, and based on everything you're telling me, again, I have no discovery, no way of corroborating what this guy's telling me except what I've seen from what little I've seen of, they're the cops. And my big glaring question is, if what this guy is telling me is true, the police have utterly deceived him into thinking he's a witness. He's merely a witness, when in fact he has a full panoply of constitutional rights that a criminal defendant would have, even though he hasn't been charged. So my position was, you either get to the prosecutor. I think I called over their office, or I think I might have beaten Judge McCurdy's door down because I knew he was available because of our trial. We had finished early. If this guy needs a plea as of now, I'm pleading him out right now, so he has all the rights. We can arraign him. He has all the rights that a person who's been charged has. We bail him out. I don't want to leave him flapping in the breeze. That's basic competent lawyering, and it was absolutely required in the circumstances. And I think that Judge McCurdy had to hail Mr. Urick or somebody from their office. I think Urick finally showed up, and my initial position was, you guys can't even charge this guy at this point because you've delayed so long. His due process rights have been violated upside down and sideways, and we agreed to tentative plea because, again, I have no discovery. I don't know the client. And, we had other stuff going on. Let's plead him. We will again, there was a plea. A plea has the plea itself. Then there's a plea agreement, which is completely separate from the plea. Like, you have a plea for charges, plea for sentencing. You can't do a plea for testimony because this guy's already given up his testimony, and it's not my problem. I mean, he's the prosecution's witness on that. But what is my problem is this client has increasingly incriminated himself every time, based on what he tells me. He starts out with after the fact accessory to the murder, and then becomes more and more involved as the police continue to interrogate him by misleading him into thinking he's merely a witness. And of course, here he is again. He's the unspoken coercion, but very, very real, that the police could charge him with murder at any time. They could pick him up off the street. In other words, his liberty has been at stake for 6 months. So I think I made a big deal about the tort problems that I saw at the time. Asked the judge to enter a plea, hold it sub curia, because, first of all, for charges, couldn't agree on sentencing. I mean, again, I have no idea what's going on. I don't have discovery. And the client wants me to represent him. Plus, I don't know that I can afford to represent him, right? Because it would be pro bono, and I don't know what I'm looking at. So I know I spent the entire day at the courthouse, and again, getting discovery was like pulling teeth. I remember there was some issues with getting full audio tapes and the police notes, because I remember one set of police notes was like Catholic school handwriting. I think that was what's his name?
McGilvery.
Yeah. It was he, and then the other detective, who was kind of a piece of work. I'd had him in other cases.
Ritz.
Yeah, he was the one who made the client fill out form, like pretend. Again, David Simon did it. Used this case. I think it was the Cooper case, where the client or the suspect. Ritz tells the suspect, "Oh, you just have to fill out a form with your name and some other stuff on it." And of course, it required, among the stuff that the suspect's filling out, are statements of fact about the crime. And back in those days, the only consequence the police suffered, it was a practice at all police departments. All the police departments had the same practice, because the only consequence was, well, yeah, it's an unmirandized confession. So the prosecutor can't use it in the state's case in chief. But if the suspect gets on the witness stand in his own defense, then you better believe that unmirandized confession comes in against him, right?
Okay, so let's go back to that day. So everybody's kind of that knows this case is familiar with that plea agreement that was written on like some drug.
Boilerplate. I mean, yeah, it was a boilerplate plea.
So was that done on like September 7th? Was that written out on the 7th or that first day?
Oh yeah, it would have been written out like in the first. I don't remember the timing, but I do remember it was my hair was on fire to get a plea and to get this guy pled. Because remember, again, this guy has got Fifth Amendment. He's got Fifth and Sixth right. His right to the process he's due as a guy who is in jeopardy for murder. That's been violated. His right to his privilege, his right against self-incrimination, his Fifth Amendment and Maryland Constitution privilege against self-incrimination, that's been violated all over the place. His right to an attorney, that's been violated all over the place. I don't know about Fourth Amendment, if there've been illegal searches and seizures when I first met him, but my point is, I'm looking at the situation and saying, the only way that this guy that anything that can help this guy is going to happen is if we enter a plea right now so that we have judicial supervision. Otherwise, this poor kid is at the mercy of this prosecutor and the cops.
Okay, so let's get back, I guess, maybe to where we kind of started this topic, and now that we've gotten to where the plea was, let's talk about the different types of immunity, like so people that are listening kind of know, because since I'm not a lawyer. I didn't know that there's several differences of immunity, and I just want to understand those.
Okay, the most important immunity that whenever we're talking about a person who is testifying, who is in jeopardy, in other words, any witness whose testimony is going to be self-incriminating, we have two types of immunity, what's called use immunity. Formal use immunity, which is coextensive with the Fifth Amendment, and every state has an immunity statute, so the feds, and what's called pocket immunity. Pocket immunity is the kind of immunity that I think the friend of Mr. Wilds, if she were to have had immunity, pocket immunity is where it's purely contractual, it's very weak, and it's where the accused says, I'm not talking until I have a lawyer and I make a deal. And then after, pursuant to a deal, the suspect self-incriminates. That's a very different type of, that's what's called pocket immunity. It's why it matters. A deal that's in exchange for testimony, it's a contract. We're dealing with a contract. It's like that's kind of, unlike what happened with Wilds, where the only contract that we could make would be for charges, and again, we couldn't even do it for sentence. My position was no jail because of the torts, but there was no way that Jay Wilds could have pled guilty to testify against anybody because he already testified. All the state had to do was put a subpoena on him, and tell the judge, yeah, we're compelling this. Jay Wilds' testimony could be compelled, is my point. Whereas somebody who has made a deal to testify, their testimony is not compelled. It is contractual. There's a big difference. Do you see my point?
Yes, I do.
Okay, and why it matters is for purposes of what's called derivative use immunity. Derivative use immunity is it's when a person's testimony, again, use immunity says we cannot use this testimony against this person to prove guilt or enhance sentencing. Just back up for a minute. Formal use immunity is coextensive with the Fifth Amendment. Where we run into problems, I think I've mentioned to you about the Castigar hearing problem. Like, we tend to run into problems when there is a question about how far whether the scope of immunity covers the entire criminal transaction. And that's where the Castigar situation comes up. But I'll skip that. Derivative use immunity is when, if Wilds had testified, he had every incentive to testify to diminish his own and Mr. Syed's involvement. I mean, they were completely, their interests totally aligned on that point, right? I mean, Wilds is only guilty of being an accessory after the fact. I mean, Wilds can't be guilty of anything unless Syed's guilty of murder. So Wilds has every incentive to minimize Syed's guilt, right? Because it minimizes his own. So the thing that one of the disputes that I believe I have with Mr. Urick would be for derivative use immunity, because Mr. Urick would have been worried that Mr. Wilds would testify that he'd thread the needle so that he and Mr. Syed would walk. I'm sure that was about
he was, yeah. Okay,
and that worry on his part.
Okay, there's another immunity that didn't apply, or that didn't apply. That was transactional, and that's probably what most people understand when they think of immunity, because when they'll say, because some person will go, I want full immunity, I don't want charges brought against me. So transactional immunity means that the prosecutor will not bring any charges against the person.
That's correct, but that's very difficult, and typically we're only going to see transactional immunity for a witness who either is the least culpable witness, in other words, the witness who has the most leverage and the most sympathetic position, because, when we're talking about immunities, the prosecutor, okay, I'm going to leave the federal rules out of it because the rules are a little bit different between the feds and the state, and back in 99 they were very different. The victim may not be okay with, because transactional immunity means no charges. That's a pretty big deal.
Yes. And you normally want to do that when you're really trying to get a big fish with a very small fish.
Right.
Maybe if you're trying to get the head of the cartel with somebody on the street or somebody, that might be an area that they might do. But,
right. But again, and one thing about transactional immunity, though, it's for the person who has the most information, too. Like, we see it in least culpable and also most informed, because transactional immunity, when you walk into a transactional immunity conversation, the deal is everything that my client confesses to is covered by transactional immunity. So it incentivizes the greatest amount of disclosure. That's when it comes in. I think of transaction. That'd be my position on transactional immunity. That incentivizes the greatest amount of disclosure because, again, everything that I confess to is immunized.
Okay. Okay, can we move on now with the kind of the timeline of, so you do the plea deal on the 7th, and then
it wasn't a plea deal because we couldn't finish it because the state can't prove the charge.
Well, that's what I wanted to talk about. That's where I wanted to go with it, please. So so then you get to discover, you got the tapes from Jay, in the period before the trial, correct? And you got a lot of discovery. Was that correct?
Yeah, it was like pulling teeth, but yes.
And then the first trial starts, and Jay has to he gets subpoenaed to testify.
Sure. Again, remember, there's no way this guy cannot testify. There's no deal that anybody could make to make him testify or to not make him testify, because as of February 28th, he committed himself to testifying. All those months ago.
Correct. I mean, he has to testify like any other
Right.
witness in a.
Right.
I mean,
Exactly.
if he doesn't show up, then they put out an arrest warrant for him,
Sure. Yeah.
like a bench warrant, and drag
Yeah,
him.
they'll put out a material witness warrant for him. And again, but they can't. Again, that's the other reason the plea agreement was so important, was that it gave the client, Mr. Wilds, leverage and protection that he wouldn't have had otherwise.
Okay. So then the first trial happens and it ends in a mistrial, and then
the first trial of the other guy, the guy. Right. Gotcha. Yeah.
So it ends in a mistrial, and then they do a second trial, and so he testifies again. I mean, he testifies at the second trial, and he spends like 5 days on the stand answering Christina's questions.
Yeah, and I don't think I could. I think I sat through the first trial because I was very worried about Urick, about the scope of the Wilds testimony. I wanted to make sure that we were good. I mean, again, because the immunity was a big issue. And I was worried about there was a kidnapping charge. I remember this looks like a felony murder case. I think I said that to you. There were a lot of problems I see the way it was prosecuted and convicted. But putting that aside, but I was not able to oversee Mr. Wilds' testimony on the second. After the mistrial, I think I could only come one day, and Christina subpoenaed me, but I think that had to do with a tort notice. I don't. Who knows? Anyway, I'm getting ahead of myself.
Okay. So then, after the second trial, he's found guilty, or Adnan is found guilty. So Jay's co-defendant is found guilty of being the principal in the murder, in the kidnapping, and the car. It was not car theft. It was just theft in general.
No, he wasn't found guilty of that. If I remember correctly, I believe there were. Let me see. Okay, we have first-degree murder, and then second degree as a lesser included. Then kidnapping. With kidnapping, false imprisonment is a lesser included. Robbery, robbery. That doesn't even make sense. There's no intent. There's no actus reus there. Theft. Again, the difference between theft and robbery, even though theft is it's a lesser included robbery, the difference between theft and robbery is that theft, the state has to prove that the owner, that the defendant intended to permanently deprive the owner, and they have to they have to identify who the owner of the property is. And if I'm remembering correctly, there's an MJF, Christina, at the close of the state's case, maybe, or at a close of all evidence, she would have got one MJOA on the theft, because I think that it was charged as owning the car, when in fact her mother owned the car.
Oh, okay.
So there was lack of conformity of evidence in charge.
Yeah, that's a different. I guess a totally different topic.
It's very important, because that was why Jay Wilds we couldn't finalize the plea until Adnan or somebody was convicted, because our position under common law, an accessory after the fact cannot be convicted as an accessory after the fact until somebody else is convicted of the crime, as a principal of the crime. And
correct, but yeah, but he was convicted.
Keeping that plea as it was because Urick didn't charge any. Typically, you see like obstruction of justice, hindering, and that, these little misdemeanors along with accessory after the fact. I didn't want that the charging document amended to include those little misdemeanors, because again, our goal was to get everybody acquitted. Because if Mr. Syed walked, then Jay walked completely, right?
Okay. So then, but Adnan is convicted of all those counts.
Unfortunately, yeah.
Like in February or somewhere, I think that's when they final. Yeah.
So then he went to court until I remember insisting that we had to wait until the state could prove could prove the murder element of accessory after the fact to murder beyond a reasonable doubt and to a moral certainty. That was the standard at the time. We subsequently got rid of the moral certainty language and element. But the state had to make that burden of proof before we could finalize Jay Wilds' guilty plea. You understand?
Yeah, that's what I'm trying to get to, is what happened in the next couple of months after Adnan was found guilty. What were the steps that, like, what happened with, like, you and Urick and McCurdy and, from February until June?
I mean, my position, and again, because this is a common law, like nowadays it probably would not go down the same way. I don't know. I mean, but under the common law, an accessory especially in this case where Wilds' due process rights were violated up, down, sideways, we dug in and said you cannot convict this guy Wilds of accessory after the fact of murder until someone else is convicted as a principal, and hopefully no one else is convicted, because if nobody's convicted, then Wilds lost.
Correct. But Adnan was convicted, so then I'm trying to understand what the process was.
Well, I'm trying to remember. I think we waited until the conviction was final, and again, there were like a bunch of technicalities. The conviction, the jury comes back with a verdict. There might be some post-trial motions, lack of sufficient evidence to support the verdict, that sort of thing. I think we waited until all of the time for filing those motions had elapsed, because, again, I'm hoping that Mr. Syed is not convicted, because that way my client was, right? So we wait for all of the post-trial motions to be filed or to be disposed of, and again, this conviction stands. And so at that point, only then can the court accept Mr. Wilds' guilty plea. In other words, only after there is no question that Mr. Syed is convicted of the murder, only then is there can the state meet its burden of proof on the murder element of accessory after the fact to murder, whether it's first or second degree, doesn't matter. I mean, now it does, the statute has changed, but the state has to prove that the murder element is accessory after the fact. I mean, accessory after the fact is just, it's a common law level of culpability. Murder is still the charge. I mean, Wilds was convicted of murder, but as an accessory after the fact. But again, because of the type of culpability, we were very insistent that the state had to meet its burden of proof if somebody else was convicted as a principal. We were hoping it wouldn't be.
Okay, but it did, and then
we filed a motion to modify Wilds' sentence too, but that was because of the tort stuff, because of police.
Okay, so then at the end, and then Jay Wilds finalizes his plea deal, and he gets a felony for accessory to murder.
Sure, because murder's a felony. Sure. But
it was 0 jail time, even though
right.
gave him 0 jail time.
But again, that was because of the police. I mean, again, remember the police at the time. When we're in criminal law, there were two issues with police misconduct. One is suppression. When the police violate civil rights, like if they take a confession of violation of Miranda, and again, Miranda is a weak argument. Let's use or in violation of right to counsel, because in Wilds' case we had violation of Miranda, which is weak, but we had violation of his Fifth Amendment right, self-incrimination, violation of his right to counsel, 14th Amendment right to the process used to, all of that. So, what my position was, the police knew what they were doing. They had policies that they could have and should have charged Wilds or given him access. I mean, he shouldn't have to be charged in order to have access to counsel. They should have provided him without access to counsel back between February and March, but they didn't. So our position was, again, all of these police torts, all of these constitutional violations, would they suppress evidence against Wilds? My position was, yeah. That's another reason why, if we did a trial on Wilds charges, all of that evidence, anything he said, in my position is anything he said after he left the police station on February 28th, could not be used against him, even if he testified as cross-examination, because the police violated Fifth Amendment, Sixth Amendment, 14th Amendment rights. But even more so, because the violations were also tort claims, our position, and back in those days, when we had to file a notice, what's called a notice of tort, if you're going to sue the police or a public official, you have to file within 6 months of the date of the event. So we had to serve the notice on the city solicitor. So we did. And that goes to the sentencing, because the minute if he lost his liberty at all, then, how to say this? Okay, as long as the police, what they had done, especially on the types of these Wells didn't. It wasn't a rough takedown. It was not a Freddie Gray or George Floyd type of situation. So, what's the damage to Wells? Losing his liberty. If he had lost his liberty for even a day, then all of these police torts would be complete, would be actionable. That was my position. And I think Mr. Urick and McCurdy, I think they all recognize that. So why Wilds not serving in jail time? Because of police misconduct. It was that simple.
Okay.
There's no other deal. I mean, there didn't need to be a deal. I don't think that. I want to say I think Mr. Urick asked for like 5 years to spend all the 2 or 3 or something like that at the outset, and I wouldn't agree to it because, again, that would have been competent.
Okay, well, thanks for. I guess that's kind of not really been known, so that's definitely something that's kind of that explanation, because there is a lot of people that wanted to know why Jay got no no prison time out of this.
Because it's the police again. Because if he went to prison, then we would have sued the police, Marin City Council, Baltimore, and the Baltimore City Police for violating his Jay Wells' right to the process he's due, and he would have been damaged by vice of incarceration, loss of liberty. But again, it's a tough road to hoe. It's very hard to prove damage without loss of liberty or, again, the rough takedown. Usually we see it in Fourth Amendment cases, rough takedown, that type of thing.
Okay, well, I think this is like maybe a good stopping point for like one specific topic tonight, unless there was something you wanted to cover more tonight.
Well, just to be clear, the plea agreement, there's a plea and the agreement. They're completely separate. I mean, the rule, again, so they're intertwined, but for purposes of analysis, we have to treat them separately because a plea for reduced charges, a plea for sentence, there has to be evidence to support that. It has to be within the guide. So if it's sentence, it has to be the guidelines, or there has to be a justification for deviation. Or for the charges, there has to be evidence to support a guilty plea. You can't just plead somebody guilty without any evidence or with inadequate evidence. That's a completely different issue than the plea agreement supporting it. And to be very clear, the agreement could not be for this Wilds to testify against Syed because it was compelled. It was compelled testimony.
Correct, but I mean, to be fair, there was enough evidence from what he confessed to and probably what Jen brought in too, that he had helped as an accessory after the fact, at least. He helped bury the body. I mean, because he helped bury. I understand
your question.
Well, I think you were trying to say that there has to be some evidence that you're guilty of the crime.
Oh yeah, but I mean, the state has to meet the beyond reasonable doubt standard, and again, for an accessory after the fact, they have to prove that somebody else committed the murder.
Correct.
There's no evidence that Wilds committed it.
No, correct. So both correct on both. So like they proved.
Yeah, but that was why we waited. That's why we couldn't finalize. That's why we can't. The evidence didn't exist until Mr. Syed was convicted and all his post-trial motions were expired. Okay. Because only then was for Wilds' purposes, for my purposes, the plea. Only then could the state prove the evidence against Wilds.
Okay.
I'm not pleading guilty until the state could prove it, and the state couldn't prove it until whatever it was. I want to say the spring of 2000.
Yeah, somewhere in there. Yeah. So thanks for explaining that. So that was good for us and for me and other people to know.
And again, what's so sad about this is I think that the amount of misunderstanding is that, like these two guys, Wilds and Syed, they had an identity of interest. And again, I still don't really understand how Syed is convicted of kidnapping.
Well, that's a whole. Do we want to get into?
Maybe, but nobody's talking about. Again, I have a really hard time with that. I think again, my position, like I said, I see it as second degree grievous. I see it as second degree. Kidnapping, all the other lists. Kidnapping, no. Robbery, that's like, there's no evidence to that.
Well, I mean, he took her wallet. Like, he did take her wallet.
Yeah,
That
but
would be,
if they can only rob a living person, there's no evidence that she was alive when any. There's no evidence that she was alive when he took her wallet. And as far as kidnapping is concerned, the state has to prove lack of consent. And again, proving that Mr. Syed deceived Hay. That's, I mean, yeah, the state has that burden of proof, but they also have to prove that she believed him. And she may have had her own reasons for meeting him. I don't know. You know, again, there's just a lot. I just think I think he was a way over convicted.
okay, well, we could, I mean, and we've talked about it before, just that, like, the facts to support one specific charge can't overlap the facts of the other one, and that's where we're kind of can be confused.
I think he was convicted of felony murder, even though he wasn't charged with it. That's been my position throughout. I think because the same operative facts for the kidnapping are the facts that support the murder, right?
That's what I mean. I guess maybe Urick if we ever talked to him, maybe he could explain the difference.
He would. If a serious first-degree murder was planned on this case, right? It was planned murder.
Yes.
And the only place that I could see it is like if I was on a jury, again, it's in those moments like when he was strangling during the strangulation event, right?
Well, but then
he didn't stop himself. That's it. That's where I even see any possible argument for intent on murder.
But then wouldn't the ride request in the morning be considered the fact for kidnapping? Because he was lying. I mean, he was lying.
That's what I'm saying. That's a deception. I mean, that's kidnapping by deception. And then there was if I remember correctly, there was a blow to Hayes' head, while she was alive, that would indicate force. But remember, you have to also have concurrence of the act and the intent. So the deception, in other words, the deception about the ride, they have to prove that she was in fact deceived. We're in criminal law. I mean, we're in criminal court here, and I recognize that the idea of reasonable doubt. It's a quantum of evidence, but it is also what's the word I look for? It's not just a quantum of evidence; it's quality of evidence, and the quality of evidence here on the deception. We have the morning, so Mr. Syed lies. He tells Hay that he has car trouble. I guess it was.
It's at there's some question of it, but at the mechanics
to give him a ride after school, right?
Yes.
Okay. Well, in order to prove, the state has to prove that she believed it. That in other words, the state has to prove that, but for the deception. In other words, that the only reason that Hay went any place with Mr. Syed was because he deceived her, and the state also has to prove that she went someplace with him. And obviously she's found dead. She's buried in one place, and last seen at school. I mean, I understand the common sense inferences, but they're weak inferences. The hard inference, I think, or I should say, solid, as in we have like weak inferences and heavy inferences, logically. The one that I have the problem with is, sure, he lies to her, but when he met her after school, did she believe him? Because that's the only time it matters. I don't know,
Okay, well, that's a...
And I think he kind of dug his own grave by lying to the police, if I remember correctly. But again, he's a kid, so I would expect that. I don't know. I mean, it's not. He wasn't my client, so I don't know. I mean, I remember something else about this. I think I read the appeal, and nobody raised sufficiency of the evidence on the kidnapping and the robbery charges. I don't know why. Anyway,
okay, well,
again, not my case, not my client. I don't know.
Yeah.
The Wilds, again, I was very concerned with the sufficiency of the evidence, because the only way to convict him was he couldn't be convicted on common law. Again, this has changed, but in the time, 25 years ago, accessory, that is, could not be convicted if he asserted his due process right. He had a right to the process he was due until someone else is convicted as a principal.
Okay. Okay, was there anything else you wanted to cover on this?
Do you have any other questions that I could ask?
No, I think you covered a lot of it, and this is a lot. I mean, it's very important stuff that I had, and we have other topics we could certainly talk about this case, but I don't think I want to delve into them now. But But yeah, like I wanted to finish up and sign off and end the recording. I just I need you to, like, once I hit the end recording, don't do anything for a few minutes. I need to
Gotcha.
process it.
Sure.
So,
Can you call me when you're done, Mike?
yeah,
Just
sure.
right now.
So, yeah. So I wanted to thank you for taking the time to make this public, and I will talk to you later. I'm going to hit the stop
Sure.
recording now.
Sure. Thank you very much, Mike. It was a pleasure to speak to you. Bye-bye now.